Justice TV is on the air.
Well,
Michael Bryant
look
here.
who is back. Look
I know.
I feel like Michael
I
Bryant.
feel like after one day, it's like, man, I have to retrain myself. That one day off. Thanks to
well,
Neil Rockkind, who did an amazing job, as he always does. You guys
he was
had
fabulous.
fun.
He was fabulous. He just was fabulous. You know, when you go away, you have to worry about being replaced. You know?
Well, I always figure that. I'm surprised it doesn't say Bryant, or doesn't say Rockkind and Bodden on the bottom. I didn't get around to changing that fast enough. Okay,
Just kidding.
you know, how you doing? Everything good?
Yeah, everything.
Lovely blouse you have on there.
Thank you very much. I appreciate this. You know, I bought this we bought this in Rome, I think, in 2021, before, when we were there in the spring. This is a very old blouse, and it's brand new, and I love it.
It's beautiful. It's
the fashion week. It's Strada. Yeah, it's the fashion week. Yeah. You know, they told me on Long Crime, after I wore it for like 4 years, that you know, with that I wasn't supposed to wear that's something bright, and you know, you had to be more buttoned up. But you know, I don't think our viewers really want us to be buttoned up. They want us to be ourselves.
Exactly. That's what, even when we send our little interview prep sheet to people, one of the things you say is wear whatever you want. You know, we don't have any uniform here. So
yeah.
Oh, wait a minute. Hold on a second. All right, this just handed me.
Woo!
That's what I used to say back in the day. You know, there was a big hubbub over Epstein documents that were going to be released today by the FBI, and we know that when the civil case and the Ghislaine Maxwell case came about most recently, there was another dump of these documents that turned out to be blah, nothing, right?
Right.
So something weird didn't happen today, but the breaking news is apparently the FBI office in New York, of course, has been sitting on a bunch of material and has not provided it to the AG as required. And so there's been an announcement by the AG that by 8 a.m. tomorrow, February 28th, the FBI will deliver the full and complete Epstein files to my office. This is from AG Pam Bondi, including all records, documents, audio and video recordings, and materials related to Jeffrey Epstein and his clients, regardless of how such information was obtained. Quote, there will be no withholdings or limitations to my or your access, end quote.
Well, that's interesting, because, you know, social media was posting pictures of influencers at the White House with like binders that had the original release of Epstein documents, supposedly the Epstein documents that were supposed to be released today. I don't know what's going on. You can't believe everything you see. And also, I trust my partner, my streaming partner, Michael Bryant, to have the best news, especially since we tend to know somebody who has an award.
Yeah, I'm going to work hard. If that actually happens, we'll work hard to see if we can get the director of Filthy Rich on here. It's you know, it's not a certainty, of course. She's a little tricky, but we'll
you want to tell people who that is?
Well, yeah, Lisa Bryant, of course. We're somewhat related, and yeah, hopefully she will be able to make some room for us. If this, you know, every time she hears the story about something coming out, it's nothing. It's going to be nothing. And they have virtually all the documents because they did the series. They have virtually everything that's been released. But if this quote from Pam Bondi is true, there's a lot more to come that the New York field office of the FBI has been sitting on. So,
well, as you know, my husband Michael Bodden, on behalf of Jeffrey Epstein's brother, did the second autopsy review. He was at the autopsy that was performed in New York at the New York Medical Examiner's Office. But that was after all this other stuff. So
yeah, and he came to what conclusion?
He came to the conclusion, I don't know what conclusion.
That it was not suicide. Yeah, remember the whole hyoid bone, the whole thing.
But he'd like to see more information, you know, because I think last time I read an article on this, they hadn't released everything in the feds in terms of the jail and all. Isn't that the case? Maybe I'm wrong, but you guys can check me.
There's definitely some holes in the investigation. Let's put it that way. Okay, so that's not what we got together to talk about. We got plenty of other stuff.
You know, we do. Oh my gosh, we could go another. You know, last night when you weren't here, just to let you know, we went several hours. We went almost 2 hours. You know, and we had a lot of chatters. We had 125 people on. And it was actually very interesting. I learned a lot. And whenever you have Neil on, it was also interesting to get his take on it, because he tries cases differently and he has different viewpoints than you and I may have, or sees things. It was just very interesting how he intertwined all the three cases we talked about last night together, dealing with the fact that a prosecutor, because this is going to be interesting as we talk about Karen Read, has to, if they have a witness who is lying, has to get up there right in court and tell people a lie is a lie is a lie, no matter what the subject. That's the Glossip case that just came down. We talked about it last night. So given the Karen Read case that's filed, given the Karen Read documents that were filed today, that the court becomes interested in every single case now.
Yeah, and we're going to go through the, what's it called again? Full-throated motion for dismissal that has been filed now. Even though it's the redacted version, there's still a lot in there. So just as a kind of a setup for that.
Redacted version. Well, before you do that, redacted version. You know what redacted version means? Yeah. It means that I wasted a lot of
your ink is what they did.
My ink, because I felt that I had to mark it up with my pen and pencil, my yellow marker today. And when I got to the end, I got a notice that my ink was out. And of course, when I go to see my ink was out, it's because redacted.
Yeah, and we'll talk about that. Was Exhibit C, I believe, that was just the whole exhibit was gone, missing. And I went back and checked, and in the motion itself, Exhibit C is not referenced except somewhere underneath the black. So I don't know what it is, because they wouldn't even identify it in the body of the motion. So we're gonna have our speculation as to what it is, and I think it's juror related, but we'll get into that. Okay, so this of course is the motion promised by Alan Jackson, a fully throated motion to dismiss that is now on calendar for next Tuesday. They've got Tuesday and Wednesday. They're going to be doing stuff up there. So we thought it'd be great.
And Tuesday, where is Michael Bryant from Justice Serve TV?
I'll be there hanging with my my folks, talking to whomever will talk to me, and it could be a huge day. It really could be. I don't expect Judge Bev to rule on this on like Tuesday afternoon, but
you're going to be there Wednesday too.
I'll be there Wednesday, and then they've got a federal court appearance in the morning, which the Judge Bev has said, yeah, go take care of that, and then hop on over here. So they'll be very busy on Tuesday and Wednesday of next week, as will we. Justice Service TV will be there, and it's always an interesting little trip up there. And the weather's getting so much better. Oh man, it's so much better. So nice. So the paperwork that was filed that we went through, I looked at it, and I think it was 147 pages, but the vast majority are the exhibits, which are trial transcripts, black pages of nothing, and a couple of notices here and there. We're going to go through those as they make sense as we're reading through the points being made. Some of the points we've heard over and over and over, and they are things like the videos, that kept popping up after having been told by the Commonwealth they don't exist, right? Oh, yeah. Or they've been written over, and then they've somehow come up. So the defense position is you had them, you knew you had them, you lied about it, you never provided them. That doesn't even address the technical issues within the videos themselves. Inverted, blurry, ghosty figures in places where they probably shouldn't be or may have been if they were fooling around with that right side tail light.
What is that you have in your hand for those of us who are tuning in for the first time?
Yes, here's I'm a giant, and this is the actual car. No, this is a scale model of the very famous and expensive SUV. It's the Lexus 570. It is a luxury vehicle. Take a look at. Just look under the hood of that baby.
Wow, look at you.
It's a nice car. It's a nice car. I have no idea. Just, Google and it pops up. So we also have, of course, I'm dragging these things out.
Whoa, what's that?
Oh, wait.
For those of us who haven't joined.
Oh, yeah, this is, they found, I believe the last number is 43 pieces of taillight. Does that sound right? Sounds about right. Oh, but wait, hold on a sec. Hold on. I found another one. I got it. When I was at 34 Fairview last time I was up there, I found this on the front lawn. So
you better be careful. You better be careful. They may come and rush you.
Some spoliation of evidence. Yeah. So let me put that in the bag. So and we had some comments
because we have a taillight, right?
Oh yeah, where'd that go? Here it is. Yeah, here's the taillight.
There it is.
That's where all those chunks came from.
Right.
So I did the hammer test on this originally. That's how it busted. Because my concern was always, how hard does a human body have to be hit by a car backing up to break this material? And it's pretty damn hard. So we've had a couple of comments, and I always laugh when people get so riled up, calling us names, or maybe they're calling me names. talking about how there were all these videos, and it's clear that this taillight was intact until the contact, if it occurred, with John O'Keefe's body. And it's just, you're crazy to be suggesting otherwise. And I mean, I wish I could see that storyline, because all I know is at 5-ish in the morning, when this vehicle backed out of John O'Keefe's, Karen Reed at the wheel, and bumped into whatever that car was that was right there. And remember, the defense,
the car moved. You can see the car
move. They slowed that video way down so you could see that it moved. There was contact. And then as it drives off, even then, you can still see this taillight is mostly intact. Right. Okay, it's not in 43 freaking pieces.
Hey, Michael, look at this. Brooklyn says you're violating Brady by not releasing your evidence.
That's right. Well, obviously, it doesn't mean anything. You can do it all the time. There's no repercussions. So this person was very upset that I would be suggesting that the taillight was relatively intact until they started finding all of these pieces all over the place. Remember, I think it was up to as many as 15 days after the date of the incident that additional pieces were found. They just kept popping up. So I think that's a little suspicious, just me. So, and we'll see that in this motion, that's obviously one of the central issues. Right. There's also the issue of the evidentiary hearing they're looking for if they can't get a dismissal. Then they're saying, okay, well, let's get into this Brady material, right? But the new angle, the new thing, this was new to me. Maybe you'd seen it before, and maybe I missed it. They're referencing in this motions juror misconduct or juror tampering.
I had not seen that before until this motion.
I had neither.
Excuse me as I blow my nose. I have a terrible allergy.
Please, yeah, don't blow your nose on that that page. That's a mess.
I'm not. So I had not. I assume that a lot of the redactions.
That's what I think.
That's for the redactions.
That's what I would think. That it's referencing the jurors and whatever they believe happened that was misconduct. So without further ado, but
Judge Bev had grave concern.
About the payment for the ACA experts. Yeah. So okay, let me see if I can get. Let's get into this. That's okay. Let's get into this. This without further ado, because it is it's a pretty interesting document. It's one of these you start, highlighting, and the next thing you know, it looks like your redacted document. There's so much stuff highlighted. So I tried to control myself. So as you can see, they do a lot of handwriting on the notes and on the motions and paperwork there in that court. The redacted version, it says. So let me get into the redacted version here. Blah, 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 blah. Okay, then let's see if this is, I want to get it as big as I can for readability. That's a little better. Commonwealth has suppressed.
I think you can go bigger.
I can, but then I'm going to lose it on the sides. And then I'm stuck. Then I can do this, but then I get a headache.
Yeah.
I'm going to get seasick.
Okay.
The Commonwealth has suppressed discoverable and exculpatory video surveillance footage from the Canton Police Department. It has provided piecemeal disclosure of some footage, most of which was disclosed after the trial started and after the Commonwealth represented that all video footage had been provided to the defense. This is kind of their prefatory language. For the reasons that remain unexplained, much of the video that has been disclosed is missing critical timeframes and evidence central to Ms. Reed's defense. Some of the video clearly appears altered or manipulated, as evidenced by people appearing and disappearing out of nowhere. So they're laying the foundation for their biggest gripe, right?
Right, which are clear, as you said, this whole theme, it's very thematic, because this whole video and the theme relating to the other, I think there's about how many points? About 8 points. It's in almost all the points.
And so they'll go through it in detail. I'll jump around a bit because most of the video complaint we know about, if not from the trial itself, from what happened post-trial, but they've done a decent job of putting it all together. There can be no doubt this video and false testimony was offered to mislead this court, the jury, and the defense by making it appear that MSP Trooper Michael Proctor, the Proctor factor, was standing next to the left rear taillight when the Commonwealth knew the exact opposite was true. Trooper Proctor was in fact standing directly next to the right rear taillight, and this references, of course, the inverted video, right?
Which interesting, because I was at Law and Crime when we had Sergeant Yuri Buchanan, I think it was pronounced on. And I was like, when he was testifying in direct, I said, wow, he's a terrific witness. He's the kind of witness you want to testify in direct. And then, like, I think it was the second time of cross-examination, maybe even a second day that he was on. All of a sudden, Alan Jackson comes back with this, the fact that this video was inverted, and said, and you wouldn't have told us unless I had brought this up. You weren't even going to tell us. And I was like, whoa, did I misread how good his testimony was?
And he was even asked on direct, or on redirect, he was asked if the video had been changed, altered, manipulated in any way. And we'll show that part of the exhibits that were attached, because that was such a key part of the testimony, and it's been used in this motion to dismiss. ADA Lowley and MSP Lieutenant Brian Tully huddled with key witness Jennifer McCabe mid-trial, prepping her on how to explain why she never disclosed that she went to CBT Sergeant Michael Lank's home one day after John O'Keefe's death, and then suppressed exculpatory statements made by McCabe during that session until a month after her testimony, at which point McCabe and other relevant witnesses were safely off the witness stand. Okay, I got this question for you, Counselor.
Yes.
If that happens to me, I'm going to make a motion to reopen so that I can bring her back on. I mean, it's just because she was excused, it doesn't mean you can't revisit that if new information comes along. Why do you think that wasn't done?
Because I think they'd gotten too far along, and they'd have to bring all their witnesses back, and their cross-examination would be different.
Well, if it was just as to Jennifer McCabe, that's where you start. And maybe that spirals into needing other information from other witnesses, but it certainly relates specifically to her. And I could see the court limiting that to her. The inquiry is only as to her because that's where this lack of information relates. Right. And there was no effort to do that. It didn't happen.
Yep. No, you're right. Right.
So I was a little surprised at that.
But we don't know the whole. Do you remember how far along 1 month after is? Where they were in the case?
Well, let's see. Let me back up and get the dates here that they're referencing. The trial ended on July 1st. Her testimony, I think, was somewhere mid-trial. So it started mid-April. So I think she might have been mid-May.
Mid-May.
I don't have that date in front of me, and they don't reference it here. But the fact is, she was off the stand. The trial was still ongoing. It wasn't like they, if the jury was deliberating, that's a different story. You're not going to be able to reopen with the jury deliberating. So yeah, I think that was maybe they in retrospect now think it was much more important than they did at the time. There's a lot happening during the trial.
Right, exactly.
Especially this one. Okay, so here we go. We're talking about here's some of the redactions, which you can start guessing what these had anything to do with. Dates of production and facts relating to discovery and constitutional violations, starting with the surveillance footage that the motion says the cops had since the date of the incident, January 29, 2022.
What could be
all
redacted
of this
there?
Redacted.
Yeah, what could be redacted there?
I just don't know unless there's a witness somehow that had, remember there was this unnamed trooper that allegedly downloaded some of the video that would have been gone by that 30-day
and
recycling
took it home
rule.
And put it personally,
and he's retired, as I recall.
Maybe it's part of the federal investigation. Maybe that was part of it.
Could be that too. So that's there's total speculation.
Right.
Okay, we get to the April 4th production. Again, this would be about 10 days, 15 days before the trial. Trial started with jury selection, I think, on the 16th or 17th. So on the 4th, 2 weeks before that, on the eve of the first trial, the missing footage from the Sallyport front wall camera would have captured a close-up of the condition of the SUV's right rear taillight upon arrival at the Sallyport garage. The individuals who had access to the right rear taillight and whether anyone removed the taillight material from the SUV before the first piece of taillight evidence was recovered at 34 Fairview Road. The condition of the rear right taillight of the Lexus SUV at the time it entered law enforcement custody is perhaps the most critical and highly contested issue in this case. It is astounding and convenient for the Commonwealth that this seminal time frame is missing from the Sallyport front wall video footage. Moreover, the data was not preserved in a forensically sound way, in violation of the February 2, 2022 preservation order, which means that the defense has been denied the ability to determine whether the Commonwealth deleted, altered, manipulated, or otherwise lost critical video evidence in its possession.
And we would point out there's another redaction there.
Yeah, that's in a footnote. That's in a footnote. So
Right.
I'm guessing it relates it's footnote number 2, which, as you can see, it relates to April 4, 2024, and the first trial. And again, the failure to disclose even the first batch of footage. So it's a footnote that relates to that. Again, is that somebody that we've not learned about before that was somehow in the chain of custody of the video?
Or a whistleblower that's come forward.
Or a whistleblower, yeah. I don't think whistleblowers do very well in the Canton Police Department. Okay, so. Oh, that's right. Then Lally, puts together his certificate of compliance, which basically means I've given you everything we've got. Certificate of compliance. This representation was patently false. Do you say patently or patently?
I don't think it matters. I think false is all that matters.
I always say patently.
I mean, it's false, it's false, it's false. I mean, whether it's patently or patently, it doesn't matter.
Just false. Tomato. Yeah. It strains credibility that ADA Lally, in light of his actual knowledge about the preservation order and existence of extensive Sallyport video, would represent to the court and to the defense that after reasonable inquiry, he disclosed and made available all known discoverable material in his possession, custody, and control. At a minimum, rather than mislead the court and the defense, ADA Lally was obligated to inform the court and the defense that there was outstanding video surveillance footage.
Well, that's interesting, because that goes to the Glossip thing. But, having been a prosecutor, I can tell you that when the police want to hide evidence, they'll hide it from the prosecutor too. You are also their enemy, okay? Right? So they're not going to go to the prosecutor and say, "Oh, I did this and I did that." They're going to tell you what they want. So I'm not, going to cast those aspersions at this.
I will cast then. It seems to me if you're the prosecutor, you got to make sure that the law enforcement folks are on the same team with you.
But they're not necessarily.
Well, then there's something wrong there. There's something wrong if law enforcement feels that they have better ideas in terms of how a case should be prosecuted.
That's true. But that doesn't necessarily mean that Lally knew that this existed. That's the issue. That the defense is saying that he did, and maybe they have evidence that he did. But I'm not willing to cast those aspersions right now.
This was another redacted area that relates to the inverted video, and all we see is the header that it was the Commonwealth producing inverted video mid-trial, violating Rule 14 and attempting to use that video to defraud the jury into believing that no one approached or touched or otherwise manipulated the right rear taillight. So again, hard to tell. Look what all those.
Yeah, it's interesting though. But remember when Alan Jackson did that, and when he was when he was cross-examining Buchanan, it wasn't right away. He did a whole bunch of I think he came back the next day to cross-examine. And I may be wrong about that, but I think there was like a time gap, and he said, that's when he said, and had I not cross-examined you, and you weren't going to tell this jury over here that this video is inverted. It almost sounds like that somebody called them, or there was a whistleblower or something in the middle of the trial that discovered, hey, look at that video, it's been inverted, as opposed to anything else. So that would be interesting to see how they learned about that. To me, that'll tell a lot. Maybe that's what this redactional has to be about.
Yeah, and again, this could be chain of custody, could be somebody we've not heard of before that they're suggesting wrongfully hid it, delayed in revealing it, or was involved in the actual inversion. I mean, I'm assuming you can intentionally or negligently invert the video, right?
Right. Exactly. Right. Sure. Just like you negligently inverted your man's hat behind you.
That's right. Let's see. Continuing on.
Except that in this case, they were all testifying about how accurate. There was a true representation, how accurate the video was, and it clearly wasn't accurate.
And so that pushes you from negligent to intentional, but you still don't know. Are you just stupid? How stupid are you that, you looked at it, there were numbers or letters that were backwards, and you couldn't figure that out? You're an idiot. On cross-examination, however, Sergeant Buchanan, his testimony was exposed as profoundly misleading at best and perjurious at worst.
Wow.
it became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality. Critical facts that neither ADA Lally nor Sergeant Buchanan saw fit to inform the court, defense, or the jury. And there's an exhibit of that part of his testimony, which is so important.
Okay. And
Moving on.
And we spent the whole other day talking about whether or not there was an outline that was disclosed.
Yeah, exactly. And when it was. And we've had a couple of comments, people saying, what kind of professional doesn't keep timesheets, referencing the invoice? Well, first of all, we haven't seen the line item invoice.
Right.
That would be a more normal way. Attorneys, bill by time. I know experts do as well.
0.1.
Yeah, 0.1. Everything's a 0.1. One of the things I learned early on was if you're in the shower thinking about a case, bill it. That's all you have to bill is your time. So yeah, maybe it took me only 3 minutes, but that's a 6-minute 0.1 bill. So you've got these experts that are billing, and by line item, they may just say things like review of documents, 1 hour. I mean, something as vague as that. So I'd like to see the line item.
Right.
Maybe we will at some point, but so far, not so much. Okay, so this is the October 10. Remember where we are. October 10, 2024. This is 3 months post-trial. This is 3 months post-trial 1. The Commonwealth is talking about new footage. They're talking about the Commonwealth new footage it provided. This is from the church side exterior, the first floor corridor, the rear lot main side, the rear lot cruiser side. All of this material just popped up, from nowhere.
Wow.
And so they're saying significantly, this specifically requested material and relevant evidence, which establishes that Higgins was on the phone. This is a mystery phone call. Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left the CPD shortly after O'Keefe's death, was suppressed until after the first trial. I don't know how they get around that. How do you get around that?
I don't know. And what's interesting is that this was put in italics. It was italicized in this, right? So this is something the defense wants to highlight, right?
Oh yeah.
That you had all this. How do you put somebody through a trial where the jury had some serious concerns? Clearly, were hung on some counts clearly, or one count clearly, and they didn't have this when they were discussing it, which may have changed the whole tenure of the jury discussion.
Well, they might. Here's a crazy idea. They might have had all the facts and all the evidence.
Crazy idea. Yeah, crazy idea.
Wacky.
Right. So on the phone as he's leaving CPD. Wow. Okay.
Here, I always forget. We get into this. I forget we have people that are leaving us questions and comments. Michael did a good
I'm
job.
sorry. As a matter of fact, I'm in the back door. I'm in the back door with you today, so I can't see questions and comments and put them up.
Right.
So
I just, of course, grabbed this one because it was complimentary. So I grabbed this one.
Yeah.
Thanks, Jason. I always feel bad when I'm not getting. I'm not a pestering kind of guy, but I don't know why there was no reaction of any kind. It just seemed
no one was asking any questions. You were the only one. You asked 2 questions.
I think
Alan Jackson and one of Alessi.
I don't know that too many others followed that direction, and I'm not sure why about that either. A couple of people yelled at Alessi, I think. And then just after asking him a question,
somebody yelled at him that he did a great job. Or
yes,
like
that's
that.
Right. That's right.
But they weren't asking questions. You were the only one who asked questions.
I remember mentioning that day how he's like this split personality dude, where he's so confident and his oratory is great, and on the street he's like this little nebbish guy. Wheeling his suitcase.
But I apologize because I entered the StreamYard link for the host, which I am, but usually I enter the StreamYard link for like a guest so that I could deal with the questions, so at the same time.
It's hard to multitask here. I know. There's a lot happening.
Right.
What's Pokemon 0730? What are the reasons for the redaction? Well, they have agreed, and it's funny, in Massachusetts they call it impounding, right? They don't call it sealing, or
they don't call it sealing, right?
So they had a specific request that they seal certain portions of this motion to dismiss, and then they did the redacting themselves, which is effectively the same thing. It's kept from our view, and we're just speculating, as to what it relates to. That's really all we can do. The reason is that somebody thinks it's sensitive, either in identifying somebody or something that could put them in danger, could put the case in danger, could reveal something that has an impact on a person. We don't know.
Right.
We don't know.
And sometimes, and also, I don't think it happened in this case, although there was DNA mentioned a couple times. I don't know if there's any DNA reports listed in there. It's hard to tell because you can't tell what is redacted, right? They did a good job redacting, quite frankly.
Oh, yeah. Yeah, they did a lot of redacting. Here's a good question from M. Crott, but the timestamp wasn't inverted. How is that possible unless initial, I think intentional is the word, I'm guessing. Yeah, I mean, sure, it makes it look like it was inverted and then either restamped or put through whatever system was originally used to put the stamp on it. Yeah, it's not very well explained.
See, that's the kind of person that the defense wants on the jury.
Of course.
Because that's one other thing. And jurors are really interesting because they pick up on things. You know, we can try a case, we live with the case sometimes 4 years, 5 years, 3 years, and then we try a case and we're there for months, and you'd be surprised what jurors will pick up on something that you didn't see, and you live with the case, but that may become important. So you never know what's important to a jury.
Yep. Actually, you know, as they say, the forest for the trees. That's the John Lewin argument. Yeah, I mean, that's what happens sometimes. You're deep into the trees. And yeah,
I'm wearing the forest.
You would be in camouflage. You would not be seen in the forest if you're wearing that blouse. You would blend right in. Okay, so more redaction, and again, this comes right after the reference to that additional video. So there's a theme, it seems to me, with the redaction. Okay, and now we're talking about an additional request, right? Remember the DVR system request where they said, oh, wait a minute, it's too bad stuff gets originally written over. Right. Upon reaching an agreement with the Commonwealth, Matthew Erickson visited the CPD on the morning of December 12, 2024. Again, 5 months after the trial. That was done to image the DVR system. He then discovered, as the Commonwealth has since conceded, that the DVR system was programmed to automatically overwrite footage after 30 days. Well, isn't that convenient? Which means the Commonwealth failed to preserve the specifically requested material and exculpatory footage relevant to Miss Reed's case via standard forensic protocols.
And there was
as
a court
they were
order,
obligated
right?
to
There
do.
was a court order that says you preserve. That's why we go in and we file these motions to preserve, because we don't know what is going to be there. And also you want it all served on the cops and all that kind of stuff. And usually you go in and the prosecutor will say, well, I have no control of the police department. You have to bring their attorney into this. You got to, notice their attorney for this hearing and that type of stuff, instead of saying, no, and I'll take it upon myself to make sure that everything is preserved. Yeah,
and you can see they referenced the February 2, 2022 preservation order. And then there was an order in October of 2022 compelling discovery of all videos and related metadata. So, I mean, that on its face, how Keystone cops do you have to be excused for this kind of stuff?
But the problem is that unless the judge is going to do something, and some of these issues have already been brought up to her and she hasn't done anything.
You're right.
The judge is going to do something. You can complain all you want, because it really is. It requires judicial enforcement, like in the Baldwin case.
Yep, that's where I was going to go. At a certain point, and that's what this motion is about.
Right.
You go, okay, you look the other way on one thing, but can you look the other way on 2, 3, 4, 5, 6, 7, however many things there might be? And this is the way to bring it, because this is, if there is a conviction, you might as well just change the header on this to appeal.
Right.
You get a lot of work already done. On January 28th of 2025, that was like a month ago, the Commonwealth yet again turned over additional CPD surveillance footage from January 29th, this time from an exterior camera that depicted the SUV as it was being brought into the Sallyport garage. The footage, although blurry and grainy, now all of a sudden we have a new problem. We have new video, but this is blurry and grainy, appears to show an individual approach the right rear tail light of Miss Reed's SUV immediately after the vehicle is brought into the Sallyport garage, and then exit shortly thereafter. If this video were not blurred out, the surveillance feed would have captured yet another angle of the right rear tail light as it entered the Sallyport garage. At a certain point, it defies logic that all CPD video surveillance footage coincidentally cuts out, blurs out, or it becomes grainy at the precise time the right rear taillight of the Lexus SUV should be in frame upon its arrival at the Sally Port. This angle of video surveillance is exculpatory and was withheld from the defense prior to the first trial.
You know what this reminds me of a little bit of? Since we talked about the Epstein case, where ironically the cell doors weren't working, right? The
cameras didn't work. The guards fell asleep.
The guards fell asleep. All of a sudden, just at the moment that there should be evidence about, who, if anybody, was in the cell with Epstein, who entered the cell, what happened, the cameras there. Everything is just disappeared. It's gone, or it's not available, or
it just strains logic and common sense that all of these things could possibly happen at the same time, or in this case, a series of events affecting the exact same material. If we didn't lose it this way, we lost it this way. If it's not, inverted, it's blurry. If there's not 42 minutes missing. And I think I have that highlighted coming up.
Right, 42 minutes.
42 minutes was just missing. I don't know.
Yeah. It reminds me of, if you go back historically, there was a president called Richard Nixon, I think, wasn't it?
Oh, yes. I was thinking the 18 and a half minutes.
Was it 18 and a half minutes?
Yeah. And what was her name? The secretary.
Rosemary.
There you go. Yep.
Rosemary.
Yep. I don't remember her last name.
Okay, community. At a time like this, Google is your friend. Okay.
Yeah. That was kind of important for Tricky Dick.
About whether or not he had ordered the break-in into the Democratic headquarters at the Watergate building at that time, and that just disappeared.
Yep. Funny about that. Yeah. Prince Lover, how does the Commonwealth still find video now? That's a great question. A very good question. That also leads me to wonder about this person they talked about as a retired officer that may have backed up the video
and taken a copy home
in the cloud, or put it on a thumb drive before it disappeared automatically. That seems to be a possibility. Oh, there we go. Rosemary Woods. Thank you.
Rosemary Woods. Thank you. At least we had the Rosemary. Wow. The world is on fire. Thank you.
It was 18 and a half. I'm surprised I remembered that. It was 18 and a half, right? 18 and a half minutes?
7?
7? Oh, I thought it was 18 and a half minutes. Okay.
I just remember it was
somebody check that.
At the beginning of the missing tapes and videos and all.
Yeah, that guy taped everything. What a doofus. Okay, so more redaction. But again, this is in reference to McCabe and her cell phone. This one of the secondary issues they're talking about here is this meeting that apparently took place between the very popular Jennifer McCabe and Sergeant Lank on January 30th, 2022, the next day. At first, she didn't admit going there, and then she said she went there to take her friend Carrie. I think Carrie was the name. Carrie was the one everybody liked, who seemed legit, like a real witness, and didn't seem so shaky, didn't seem to be part of the McAlbert clan. So she said she was going there to either pick her up, or she had a child she had to pick up. Anyway, she said she never talked to Lank, that it was his house, but never talked to him. So that apparently was far from true. On May 7, 2024. So here we are about 3 weeks into the trial. In accordance with this court's order, that parties disclose all information to be used for impeachment purposes. And I thought that was interesting. What's your take on that, LKB?
Well,
the court actually required. Well, you probably went through it with Aaron Hernandez, right?
They require, at New Jersey, they require to give impeachment evidence. At federal courts, you have to give impeachment evidence. It's not unusual to be required to give impeachment evidence. The whole idea is that you want to hold that back because you don't want them to know to explain it beforehand. But most courts are now requiring you to give impeachment evidence.
In California, unless it's recently changed, they did not. And that was, my motto was a surprise a day. And so that's a good way to
if you have
surprises.
Somebody's a liar, and it's not in your case in chief. But now the courts, the federal courts especially, if it goes in that pretrial memo that you have to do, and unless it's come up during trial because somebody's testified a little differently, and then you have something, if it's not there, you're not going to be impeaching with it.
Yeah. So this relates to the phone, which would tell us where Jen McCabe was on that day where she said, "Oh yeah, I forgot it was at the sergeant's house, Lank." So it says here, Attorney Little emailed ADA. Little is Elizabeth Little. She's one of the original 3 that were involved from the defense side. And she does a lot of this behind the scenes, administrative, connecting with people, getting things prepared, less a voice in court, although she did speak the other day.
Right, but I had never really heard her before until the other day. And Neil pointed out yesterday that when he had both Yannetti, Jackson, and Little get up there because the judge wanted to question them, and unless he was trying to prevent that, because that's not what he had represented, the judge could ask. It reminded him of, remember the tobacco people, the tobacco heads in front of Congress. They all stood up, all 5 of them, with their hands up, and he said, it kind of reminded him of that.
Yeah, she was asking if everything Alessi had said was correct,
right,
in their recollection. That not a bad way to kind of confirm what the guy's saying, because remember, with he and with Brennan, they weren't there the first time, so here you have these guys kind of resurrecting the history that they did not live. Let's see. So McCabe's cell phone, establishing that she went to Sergeant Lank's house on the 30th, unbeknownst to the defense. ADA Lally and ADA McLaughlin shared this impeachment information with Lieutenant Tully. Curious.
Who's Tully? Who was Tully? Tell us who Tully was.
Well, I'm trying to remember his role other than as one of the investigators in the operation. I don't know what they're referencing specifically, but sharing the information with the cop sounds like there's some reason for that, to coordinate testimony or evidence in some way. On May 10th, in a then undocumented meeting, Lieutenant Tully, ADA Lally, and ADA McLaughlin met with McCabe shortly before she was scheduled to testify in the first trial. McCabe's materially inconsistent statement about meeting Sergeant Lank was not memorialized in any report or otherwise disclosed to the defense in advance of her testimony at trial. That is a Brady violation, they say, and Rule 14. So
they're coming to get you, Michael. They're calling me to find out where you are.
Find out where I am. Good thing I'm in the witness protection program. So they're basically the defense is painting this picture that there was this coordinated effort between the prosecutor and law enforcement to hide McCabe's location that day because they don't want the jury to think she was having a conversation with Sergeant Lank about the testimony she was going to give or the investigation and how she was tied to it or not tied to it. I mean, remember, she's as key a witness as anybody, having been there when the body was found, having been at the house earlier that evening.
Right.
And she's one of the most unlikable witnesses that appeared in this trial. So,
I remember when we were commenting on the case at Long Crime that people had very severe views about her. I mean, really severe views about her. And then people who, of course, believe that Karen Reed is guilty of some type of crime had wonderful views about her. So I guess you filter that through your lens of what you want to happen.
I think it's safe to say she's a loyal person. How about that?
Yeah. Yep.
Okay. So she testifies she's at the house for about an hour and she, quote, might have ran in to go to the bathroom, end quote. So this is her massaging what happened to support that, I forgot I was there. May have gone into the house to use the bathroom, but that's it. There was no clandestine meeting with Sergeant Lank, right? Then there's this little redaction here.
Another redaction.
And I'm not sure. And then it picks up with on cross at trial for the first time, McCabe mentioned going to Sergeant Lank's home and admitted that she discussed the issue at a meeting a couple of weeks prior.
Could that again be somebody who, let's see, I'm just trying to testify.
Somebody that was, maybe there was a confidential informant involved.
A crime across the trial. After something, somebody who's talking about something, I don't know. Remember, there was also a federal investigation, which apparently is ended and will be announced as it's ended. Maybe, I don't know if it ever is. Maybe some of this information was gleaned from that.
It's all very possible. It's just total guesstimation. But this looks different than the other stuff that was totally related.
Very
to
small.
Video. Yeah. Okay, moving on here. More redactions as we get. Remember, I talked about Exhibit C.
Right.
This is Section C, which looks Pretty good.
There it is. I'm looking at my thing. It looks really good.
Whee! Doesn't even give us the caption for what it is.
Right.
So that's interesting.
Right. You know what we should have done? We should have put this through AI and asked what would be the likelihood. Yeah, ask AI to guess what. As a matter of fact, our viewers, you can do that, right? Put this through AI, or sections of it, because if you try to put the whole thing through, I doubt it will do anything. And see, I don't know what the different AI programs are now, but what would be anticipated to be at these various redactions? I mean, I'm sure that there is somebody out here who's tech savvy who can put every single thing through, put the whole thing through, and then ask on these specific areas, what is the likelihood
What's the
logical likelihood of the wording in here that could be in here?
Okay, I will wait for a report on that.
Well,
Linda, question for you from Shy Gal.
Yeah, there's people doing it.
Shy Gal has a question for you.
Okay, hold on a second. Linda, if this trial continues, would you stay with the cover-up defense as opposed to she just didn't hit him? I guess you have to have a reason to say why the cops brought these charges. So, and that's the issue. You have to have a reason, right? I mean, I think she's got a good case for the car didn't kill him because the two medical examiners and ARCA, even if they may be, have been paid by Jackson after the fact, all came to the conclusion because they were hired by the feds that the car didn't hit him, the car didn't cause his death. So then you have what caused those things on his arm, and that's where you're with Chloe. And maybe it wasn't so much as a cover up, but just that it was an accident. People figured, hey, I'm going to get blamed for this. And we didn't do anything. I mean, I don't think I would stay with, if it were me, with that he was intentionally killed, inside the house, and it was intentional killing. But there could be an accident that people just didn't go out and
that's kind of what I think. And we got to remember this: it's not an affirmative defense. They don't have to prove a damn thing, but they are leaving those questions hanging in the air.
Yeah, or they were all out drinking and they knew that he was blitzkrieg maybe, and they let him walk out of the house.
Yeah, he stumbled out. Maybe there was an altercation in the house. Maybe there wasn't. All of that means really nothing in terms of proving what happened. Doesn't matter. It doesn't help the prosecution prove their case.
Right. So it doesn't help the defense either, right? Maybe it does because.
I think it definitely helps the defense because you got all these questions that make you wonder what the hell happened, and what the hell happened is not beyond a reasonable doubt. So I think we'll see all of that thrown out there again. We'll see all of those questions thrown out there for this jury to think about.
But sometimes, wouldn't it be wise to say, well, we don't know what happened in the house, but these, whatever it is, the dog was out. Maybe people felt guilty. Maybe they, we're cops. We're going to get blamed. We know how this works, and therefore, well, okay, here she must have hit him. I mean, that's a possibility. What would you think about that, Shy Gal 8? Because remember, when we do these cases, we've already either mock tried them on these big cases, or have had a number of focus groups to see what it is that the jury thinks. So what goes best with the jury, or what jurors think on their own they're best based on the facts that are presented to them. So I would bet you that this case has been mock trial. Well, obviously had a real trial one already, mock trial before it was tried, or forensic or focus groups by a jury consultant to see. So I don't think that was just laid out there. And, there's, and remember, there's a federal investigation we know nothing about. We know nothing about.
Nothing except that we think it's ended and we think nobody's going to be indicted. That's
all we know.
That's what we're hearing. I forgot I was going to do this. I'm so horrible at this. We're supposed to say hit the like and hit the, we're supposed to do that right at the beginning.
Right. And the middle and the end.
Yeah,
we have 112 chatters. Could you all right now just
one time? Ready?
Like button
1,
right
2, 3.
Like,
I got to change my attitude because I'm not like us. I don't think of that, but I guess
we've been told that we have to do that. We're members of the YouTube creators, and apparently we're supposed to say it when we get on. We're supposed to say it we've been talking for 3 minutes, and again 3 more minutes, and again and again and again. But yeah, let's create a wave here. Let's if let's assume we're at a football game. Maybe not my Jets, even though I am in green.
Hey,
we got it. Button. Everybody hit the like button.
Don't mention the Jets because you know what the rumblings are about Aaron Rodgers.
He's out.
He's out. But who you know where they're going to send him?
Where?
What he's talking? L.A.
Well, you know what? He's going to bring you home a Super Bowl because the Jets, after four plays, calls his ACL tear. Statistically, he was the best quarterback we had the second year since 1969. 1969. Okay. But, you know, we're the Jets. So what can I tell you? You know,
well, that would be just poetic justice for your Jets.
That
right?
would be so perfect. Yeah. You would see I have my Jets back here. And
okay, so now we're back to the inverted video in this part of their motion.
Okay.
The Commonwealth violated Rule 14.
Where are we on the motion? Okay, I'm sorry.
Well, let me back up to a header, a big header.
On a header. In case those of you also have looked at it and want to follow
this is their argument. Basically.
Okay, we're in the argument. All right.
Yeah. So a lot of facts, argument, and then law, which we skip over because it's the law. and it's just the citations from cases.
And by the way, what we didn't say is that this motion is headed Defendant Karen Reed's motion to dismiss for extraordinary government misconduct. And I love the word government. You don't say the state misconduct, Commonwealth misconduct, government.
The big bad government.
Yeah. So, but this is how it's headed, by the way, before we get back into that.
So first, the Commonwealth violated Rule 14 in this court's October 5, 2022 order compelling production of the video evidence by withholding the inverted video from the Canton Sally Port until after the start of trial. So that's, again, these are the same arguments we've heard throughout the course post-trial, post-trial number 1. They also talk about the Brady issues. After this trial of this matter on October 10, the Commonwealth produced previously withheld video surveillance from the church side exterior and rear lot cameras, which show inter alia, dropping some Latin in there. What does that mean?
Among other things.
Among other things. Higgins' arrival in the parking lot.
So wait a second. Wait. Who's on trial here? Who's on trial?
Higgins' arrival in the parking lot. This, to me, is very interesting. This mysterious phone conversation with somebody at 1:34 a.m.
Explain why. You're in the jury room. Explain why you think this is mysterious.
Remember when this took place. This is at 1:34 in the morning. The incident took place at or about 12:14-ish, 12:15. That's when Karen Reed drops him off, right?
Right.
So this is before he's even found. Technically, right? He's not found till 5 or so in the morning.
In the morning, right.
Well, at least according to prosecution's theory, we don't know what happened, if anything, in the house that left him out there on the lawn. We don't know. But maybe Higgins is talking to somebody who's needing some help, like somebody that's been involved in whatever happened to John O'Keefe. And he or she calls Higgins at 1:34 a.m. because he's a cop, right? And he can help. I don't know. I just think that's going to be.
That's what the defense is going to say?
Well, I think they're going to suggest that the timing is very interesting. And why was it hidden from us?
Why was it hidden from us becomes the issue, right?
Well, yeah.
And of course, the defense is the prosecution is going to say, well, because it wasn't important, it wasn't exculpatory. The defense is going to say everything is exculpatory in this case.
And then we've seen how judges like when prosecution and law enforcement decide what is and isn't exculpatory.
Yes.
It doesn't usually go well for them.
Yeah.
Let's see.
I love it when you get to when you don't get something and the prosecution says, well, we put it through our Brady unit and they didn't find it exculpatory, right? We put it through our Brady unit and we found on your behalf that it wasn't exculpatory. Okay. Yeah, that really
here's a correction for me because I put him in the whole law enforcement pile, Higgins, ATF. But you know what I'm talking about. He's somebody that might be able to help somebody with an issue late at night where somebody's maybe either disappeared already or is not doing well. We're not sure, but the timing is very suspicious.
Who was the person that was dating, wanted to date her, was sussing it out? Who was that fellow?
Higgins.
That's what I thought. That's why I mentioned it. He was sussing out the relationship.
Yes.
Sussing. I always say that. And when you say sussing out, that's what it reminds me of, like when we were watching the Johnny Depp case, and the attorney for Amber Heard kept saying, "Did I read that right? Did I read that right?" A funny story. Just as when I was at Harvard this year, one of the young students said, "Did I read that right?" in doing his day of cross-examination, and I said, Stop. Stop. Those of us who sat through the Johnny Depp trial don't pick up that as a lingo to use. Obviously, he must have picked it up there, right?
Yeah,
Because you try to learn from everybody you watch, but no, don't ask that question. Don't preface your cross. Did I read that right?
Here's another one you don't want to use. Listen to my question. Don't steal that one either.
That is from class. Class, that is from.
Oh, that would be John Lewin's favorite line.
John Lewin. Listen to my question. Or what I asked you was. What I asked you was, and listen to my question. Both of those were like when he asked the question, he doesn't get the answer he wants. And there you go. One of the things we didn't go through though, Michael. I know we're going through this line by line. We're in the argument.
Yeah, we're almost done with the actual motion. Yeah.
Okay, but I want to talk about what their basically 8 claims are. The headers of their 8 claims.
You have them listed out there?
Suppression of evidence. I think I emailed them to you or texted them to you earlier. False testimony. Late disclosure in violation of Brady, like really late. Destruction of evidence, and purposely, I think they're saying. Improper witness preparation. Actually, what they're alleging is witness tampering, right? Constitutional violations. Then they also want the case to be dismissed. And if the case isn't dismissed, is what you're getting to right now.
Yeah, that's the juror issue is very interesting and new.
Yeah, tell me about the juror issue.
And I look at it, it's preceded by a lot of redaction. This is sub C. Dismissal is the only appropriate remedy for the violation of Ms. Reed's Sixth Amendment right to trial by an impartial jury.
Well, it is interesting because Alan Jackson did, or was it Alan Jackson in this motion, or was it just the other day when we were talking? Was it Alessi that the jurors, had called? Right? Or no, it's in this motion. It mentions the fact that the jurors were hung on 2 issues, right? Or reached a not guilty on 1 issue. Right at the beginning. Let's go to the beginning. He actually puts it better than I could put it.
You have a page reference?
Yeah, I am going to get there. Oh my gosh, they're coming to take you away, Michael Bryant. They're coming to take you away.
It's your phone.
Whatever it is. Well, I know I'm sorry. I have the door open so that Tubi can come in and out of the office and didn't close it. And hold on a second. I think it may even be, is it in a footnote or is it in Alan Jackson's affidavit? Okay, all right. It's footnote 1.
Of what page?
Okay. Of page 4.
Okay, well, let me set the Wayback Machine here.
Well, that's right. I can read it while you.
Okay, well, I'm able to look at it together. Okay, there it is. Gotcha.
Okay. All right.
In the days and weeks, go ahead.
In the days and weeks following the first trial, 5 deliberating jurors have come forward and indicated that they had unanimously acquitted Miss Reed on counts 1 and 3. Now, those counts are manslaughter, and count 3 was leaving the scene of personal injury and death. Okay, all right. Unanimously acquitted Miss Reed on counts 1 and 3, and were hung only with respect to count 2. Count 2 is the count 1 was the murder, and count 3 was leaving the scene. Count 2 is the manslaughter while under the influence of alcohol.
Yeah,
apologize for that. All right. They indicated they did not believe they were permitted to report the unanimous decisions on count 1 and 3 unless they were able to reach a unanimous verdict on all counts. And Ms. Reed's failure to address any claims of double jeopardy in the instant motion to dismiss shall not in any way be deemed or construed a waiver of those issues which are presently pending before the United States District Court for the District of Massachusetts. So I'm thinking that because there's an alternative request for a hearing, that it goes back again to this whole idea of what jurors may have said and what they may have said since they have filed the motion for double jeopardy.
It's an interesting speculation. I don't know. Why would they label that as some sort of juror misconduct or juror tampering?
Well, maybe some of the jurors now, in terms of interviewing them and probably having an investigator going out to talk to people, finding that maybe some other jurors possibly were contacted by third parties or people on behalf of the prosecution. That's my guess. And now I don't know that for a fact. I have no indication of that, but I'm just saying that with all these redactions right now, it's something serious, right?
Yeah, and this is on balance the area that has the most redactions, and that's clearly to protect somebody's identity, I would think. I mean, they just the only thing they leave open in this very first part of the argument is jury tampering, such as this, is presumptively prejudicial. So,
so the
whenever they
jury
aren't
tampering
telling us right here,
right. The jury tampering has to have come after we had the motions for the double jeopardy in Judge Cannoni's courtroom. By the way, I apologize for the phone. Next time I will close my office door here. I apologize.
Sounds like we're in a boiler room. What do you got? You got people on the
I don't know.
1-800 lines?
Somebody who really wants to talk to me. That's all I can say. I have a cell phone, but not everyone has my cell phone number. Have you guys LTO UX or LTO?
Oh yeah. Have you guys ever seen a case like this before? This just seems wild to me.
Wild to me too, right? I mean, you know, we've had cases where there's possible juror misconduct. We saw Murdoch, right? The case of well, it wasn't juror misconduct. It was Becky, the court clerk misconduct.
Miss Becky, and of course in Baldwin we've seen, you know, evidence that was withheld, a violation of Brady. So this thing has it all. You know, none of these things are all that unique, but you put them all together in one case, that's unique.
Right. So, I mean, but this juror misconduct, go ahead and keep talking about that, because I think this is a big deal. I mean, whenever you're talking about possible juror misconduct, or because they're not saying prosecutorial misconduct or law enforcement misconduct for contacting a juror. They're saying juror misconduct.
Well, so let's walk that through. Let's assume that there's some issues that are proven, and there should have been jurors dismissed, right?
Right.
Well, then you're right back to the same double jeopardy argument, aren't you? That you've been putting forward, because what's the remedy if you had jurors that should have been removed and weren't?
And they right, exactly. That's the same. That's the remedy. Has anyone seen, of our viewers, Juror Number 2? It's a Clint Eastwood movie. It's a little
I did watch it the other day.
Yeah, it's interesting because it raises interesting ethical issues about certain things.
I mean, it wasn't one of my favorite Clint Eastwood directed movies. Right. You really have to suspend disbelief quite a bit.
True.
You know, I don't want to ruin it for anybody, but I'll just say one of the jurors has a very interesting connection to the case.
Right. You have to suspend disbelief, but it does raise ethical issues in terms of certain things involving jurors. That's all I'll say.
Yeah. I just like this language on page 29. The Commonwealth's underhanded decision to surreptitiously reveal impeachment evidence to McCabe in advance of her trial testimony and then withhold her exculpatory statements to law enforcement is a gross violation of the Commonwealth's constitutional obligation under Brady and its progeny. So, you know, the McCabe was a double whammy, you know, for them, and the Commonwealth was propping her up, putting her on the stand. And I think that McCabe argument, I think, is a good one.
I think that's a good one, but I'm really interested in this jury misconduct argument.
So am I. I'm more interested because it's intriguing. I just think in terms of substantive impact on the prior trial or the upcoming trial, I don't know what it means. I don't know that
because we don't know the facts. Hey, wouldn't it be nice to have all the facts when you're making a decision or having, you know, viewing something?
That would
as
be
you said earlier.
That'd be great. Let's look at a couple of the exhibits before we toddle along here. We've already been jammering for an hour here.
Yeah, and we've gained more viewers. We're up to 148 chatters right now. So clearly the word is getting out there that we're talking about this case. We're talking about this motion. And by the way, until we went on the air, we kept checking to see if Judge Cannoni issued an opinion on the hearing we had about whether or not there was some type of violation of either Brady from the defense point of view, or just Rule 14 they call it, in it's not really Brady because it's the defense, but Rule 14 discovery or ethical issues that would lead to some type of penalty or the pulling of any type of pro hoc vice on behalf of the out-of-state lawyers. And obviously there was no opinion released today. And I will say, Neil yesterday said, "Are you kidding me? She may decide to do slops. She may do anything, but there's no way she's going to put off this April 1st trial date with all this going on. There's just simply no way."
You know, she just seems bullheaded about it happening. You know, I mean, obviously, if the defense doesn't get their motion to dismiss granted with prejudice. I find that highly unlikely. Their fallback position is they want an evidentiary hearing on these different Brady violations. That could take a long time.
Right. So that's what they asked for dismissal. So after they say dismissal due to the alleged misconduct and resulting prejudice against Ms. Reed, the motion requests the dismissal of all charges with prejudice, arguing that no other remedy can address the harm caused. And then they say the alternative is if dismissal is not granted, defense sees an evidentiary hearing to further establish misconduct and the impact on Ms. Reed's right to a fair trial. Now, this juror issue, what we have not heard about, possible juror misconduct, that's something that
I know. I'm not as I'm interested in it, but I'm not as enamored with it as you are in terms of the substance, because there's not a conviction here. If there were a conviction here, then it's a whole different animal. Then juror misconduct and the refusal to remove jurors that should have been different animal. Well, you got effectively a hung jury here, and so you got a new trial coming anyway. So I don't know if the remedy is really that big a deal. Look at, though, the very last sentence in the conclusion. Okay. If they have an evidentiary hearing, witnesses including but not limited to ADA Lawley, ADA McLaughlin, ADA Brennan, Lieutenant Tully, Chief Rafferty, Trooper Proctor. Oh, he'd be back.
Oh, we didn't even talk about Proctor except for one.
Sergeant Buchanan. Yeah, I saw it. There was something on calendar today. Some furtherance of his hearing, I thought was pushed to today. Colleen Crawford, other members of the CPD, and Lieutenant Fanning. Yeah, you think that might take a while if that were to happen? Yeah, so
take a little bit of time.
No, let's look through some of the exhibits real quick, just because I think it's interesting to reinforce what we may or may not recall from the trial. And this is the way they do this mechanically. It's very simple. You have an affidavit. In this case, you see affidavit of Alan Jackson. He attaches to that affidavit the documents that he is attesting came from the proceeding. So it's just kind of a cover sheet in a way.
Which, by the way, had she pulled his pro hoc, they couldn't even file this motion if he were the one attesting.
Somebody else's name would be on it.
Yeah.
So look at this. Look at number, again, this is just a reference to the exhibits. Attached as A is this, attached as B. Look at number 7. Nothing. Guess what that relates to? Exhibit C.
Which
the one that is just the black pages.
So we have no idea what Exhibit C is.
No idea what it is, what it relates to, none of that.
Okay, so I want you to stop. I want you to all hit that like button now, because you see, you didn't even know that there was an Exhibit C that none of us know what it's about. Everything is redacted. I mean, it would take you. Michael Bryan spent all day, by the way, going through all this today. It's truly full-throated. That's all I can say.
It is full-throated. That is very true. So I highlighted Exhibit P because I want to look at that. And that has to do with the May 10 interview with Jennifer McCabe, which is the critical information that she gave to Sergeant Lank. Is that his name again? That actually was somewhat exculpatory in terms of what happened in the early morning hours when they found John O'Keefe's body. That's reference again to the evidentiary hearing. Let me zoom ahead to Exhibit. I won't be looking at Exhibit C, I'll tell you that.
And while you're zooming ahead, Ms. 865 Scorp C? Scorps, I know you've been on before, and I never get names right because I'm not sure what your handles. I know your handles mean something.
I think it's 86 Scorps or S Corp.
S Corps. Yeah. Oh, Ms. 86 S Corps. Okay, thank you. The fact the jury felt intimidated by having the McCabe's in the courtroom proves reasonable doubt it should have been a not guilty. Interesting point.
Yep.
Interesting point.
The
and maybe wait. How do you know the jury felt intimidated? Is there something that you know that we don't know here?
Interesting. Here's Exhibit C.
We have an email. You can email us at
justtoservetv@gmail.com. That's the latest.
Yeah, Missy's going to put it in the chat.
Exhibit C, here it is. It's a black hole. It's 4 pages of nothing.
Wow.
So that's very interesting. Okay, so I'm going to look at P. I'm going to look at first. Let's see. Oh, this is as we're moving along through the highlighted stuff. It reminds me of why I did it. This is from Exhibit D, which is the continued testimony of your boy Buchanan, Yuri Buchanan, right? So this had to do with the Sallyport video.
The one I thought was when I was at Law and Crime was a great
Interesting,
witness
so
on
great,
his
yeah.
direct. And then he got on. Then we got on the wait a second, the infrared video. I was like, whoa, did I misread that?
And this is part of that testimony. What was the time what is the time stamp where the video was paused? 5:50 and 46 seconds. 5:50 and 46 p.m., correct? That's correct. So it appears that this video is about 15 seconds. In about 15 seconds, jumps 42 minutes to the 5:50 mark, correct? I don't know how much it jumps. Well, from 5:08 approximately to 5:50, and that's how much time is that? He says approximately 48. Okay, not a math major. 42 minutes, right? Excuse me, 42.
I'm feeling him because I'm not good at math either.
Well, that was a pretty simple number. 50 minus 8, come on. Anyway, so that's the mysterious 42 minutes that disappeared with the 18.5-minute Nixon tapes. And 42 minutes from when the car arrived until 5:50 in the evening. That portion is missing, correct? It's not missing. It's just not recorded. It's not there, Sergeant Buchanan. I'm not splitting words with you, splitting hairs. It's not there. It's gone, correct? It's not on the screen. No, it's not anywhere, is it? I do not know. Oh, man. Nothing a jury likes better than somebody that won't.
Yeah. What I asked you was.
But jury doesn't like, what's 50 minus 2? I don't know. I'm not sure. Well, it's 42, isn't it? I'm not sure. That's
50
how it
minus
comes
2
off.
is actually 48, but
sorry, I meant minus 8. Let's see.
You're not a math major either.
I'm definitely not. Otherwise, I would have been a doctor. As far as the condition when you received it and the condition when it was played, again, we're talking about this video for the jury. What was different? This is the redirect. This is the attempt to rehabilitate that horrible phrase. There was no manipulation, alteration of the video between objection. I'll allow the answer. That was my Bev. Between when we received it from the Canton Police Department when I played it. I mean, that's just flat ass lying.
And under the Glossip case, if you're a prosecutor, you have a duty when you're, I'm going to say it again, because this case was so important to get up there when your witness is lying and correct it right there. Because a lie is a lie is a lie, no matter what the subject.
Yes. Hey, you mentioned some DNA when we were going over this earlier, and so I went back and looked at this. This actually related, if you look at the date of this, this was Exhibit F. The date of this Commonwealth Certificate of Compliance.
Okay.
It dates back to, where'd it go? April 10. So this was before the first trial. And they were talking about the filing is made with the present lone exception of material still undergoing mitochondrial DNA testing at the Bodie Technologies lab. I think that was cleared up before, remember there was no dog DNA and all of those issues. So I don't think any of the redaction relates to the DNA issue.
Yeah, I just was worried that perhaps somebody's profile was in there as one of the exhibits.
Dun, dun, dun. We found some new DNA.
Yeah. So that's all I was concerned about.
I think that's all I've highlighted.
Yeah, well, that's really when you go through it, that's pretty much the motion. And most of it we can talk about pretty intelligently with everybody who's chatting. But with the exception of the allegation of some type of juror misconduct, which I find
it is fascinating.
Most fascinating.
So next week,
we're not in the know. We're not in the know. We can give you what we think, but
educated opinions. That's all we got.
That's all we got, right?
We're putting the pieces together, trying to think how will that blob fit into the story.
And what's on for next week? I know we're waiting for the judge's decision on the whole issue we had with the discovery violation. But when you read what Neil was talking about, and I wish he were here right now, and I don't think Neil's in the chat. Is Neil's in the chat? No, I'm in the chat because he spent 2 hours with this. He was saying prosecutors do this type of stuff all the time, right? But when the defense has a blip, right? When the defense has a blip, it's a big deal. We get taken, and I've been a prosecutor. I've been I'm a defense attorney now. We get taken for task by it. We're going to get sanctioned. We're going to get this. We're going to get that. But when the prosecutors do it, it's like, okay, we'll turn it over. You'll deal with it. Don't worry. As Neil says, you get the pat on the back. Miss Kenny Bond, she's a great attorney. She doesn't need much time to deal with this, and that's what happens.
Yeah. Oh, yeah. I almost forgot. First Disney nerd. I say it has something to do with Lieutenant John Fanning being in charge of the jurors. And also being the reason at least one, if not two jurors were being removed close to the end of the trial.
Oh, wow.
Very interesting.
Interesting pickup.
I want to share something that Dizzy made, and I think we should put this, we can make this available, Missy, I think, on something.
Yeah, that was what we went through last night.
Oh, you guys had this last night? Cool. I did not see it.
Oh, wait, no, I'm sorry. This was not the last night. Last night we did the ARCA. We did it from the defense. We did it with the allegations against the defense, which we should make available too. What we did last night.
Yeah, you should. So anyway, this is, I won't belabor it, but you can see if you wander down the crooked path here.
Yeah, that's I missed it. Yet last night, the funniest thing is I was wandering it, and I kind of, it was like a horse race, right? And I kind of missed one of the turns. If I was in a ski salon race, I would miss one of the posts. But yeah, no, this is, I think this is really very good. And we also have
really a good
alleged violations of ARCA last night too.
Yeah, it's a good roadmap. So we'll just post that somewhere somehow.
I think we had
page.
I guess we could can we post these on community pages? Do you know?
I think we should be able to.
Yeah.
Anyway,
I'm not worried. I haven't learned all the ins and outs of all this posting yet on all of our pages, and whether we could, I know that for when we start the Finding Stephanie who killed her, we do have a Google account that we're going to password everything loaded in there already. But I'm not sure. Disney nerd at Lisa Caron. I worry she can't be unbiased because I think she hates AJ. Oh, they're talking about Judge Beverly Cannoni, I guess. We'll see. Anyhow, I think tomorrow may be a big day. I maybe think we're going to get her opinion because I don't see how she can let Alan Jackson come back without, and also filing these motions. Without having some resolution. What worries me is that this should be in the slam dunk, like nothing's wrong here. I found nothing wrong. Blah blah blah. All. But clearly, she's writing an opinion. Now that may be one way or another. But part of the problem is I think some of the harm has been done to the client by having her attorneys and maybe her experts have the prosecution have a roadmap to how to affect them. And I think any disservice has been done by having that hearing and open. She could have had that hearing closed. She could have had it in chambers.
Yeah, that's true.
And then sealed it, just like we haven't seen the sealed transcript yet
from the ASAP
Rocky, the judge, where we're going to send out. We've been so busy with now this, we haven't had a chance to send out again our request to the DA to answer the questions about ethics on that issue, and we're waiting for that transcript. I really want to see that transcript because I know when John Lewin came after us, one thing he never said was that we were wrong. He just said Mr. Tacopino
shouldn't have talked. Should not have talked.
He never said, oh, by the way, what was reported
that's a lie
by Justice Serve TV was wrong. All three times we had exclusive scoops on this. By the way, I see that Joe Tacopino, just as an aside, is going to be on, is going to go to OCTV tomorrow night not tomorrow night, Saturday at 5 p.m. our time, and be on the Shorty. So Justice Serve TV is a gateway for a lot of people coming through us and finding other sites. Again, before we move topics a second, and you can all keep chatting on this because we'll still answer your questions. But please hit that like. For 146 of you, please hit that like button. Share our channel, subscribe, notify. But hit that like button tonight because we understand that's the important button. That's Tubi. That's Tubi the Poodle.
Tubi's just
actually weighing in. He said, I like it a lot. I'm barking at you all. Yeah. All right.
I forgot. What other topic are we doing?
Fani Willis.
Oh, we're going to hit on that real quick.
Just real quick because next week we'll have a story. Fani Willis. Oh, our friend, and we did text with Ashley Merchant today, but she had another opinion that came down on another case that she was busy with tonight, couldn't come on, but we knew we'd be busy with you with this Karen Reed, and we're hoping to get her on next week. Fani Willis. Let me read you the headline of the story. This court disagrees. Judge strongly rejects absurd effort by Fani Willis to avoid subpoenas for the documents and testimony about the Trump RICO prosecution. And what this is this was her motion to quash the subpoenas issued by the state legislatures about her, quizzing her about the documents. Okay. And remember, our friend Ashley is involved in this case. She actually testified before the Georgia Senate Committee in August of 2024. A subpoena was then issued. Fani Willis was a no-show, and the parties have argued it now in the Georgia, I think, appellate courts, or was it in the Supreme Court? It went to the Supreme, and anyhow, I think this was a 2-page order from Fulton County Superior Court. They disagree that this should be quashed, and thinks that Fani Willis's motion to try to quash the subpoenas is absurd. Okay.
Yeah, and it's just ridiculous. And I remember Ashley sitting there. She has this big black binder, right?
Right.
She's citing like very specific details, left and right, and had citations for them. And I know the committee was impressed. Hey, let's revisit just a moment of this.
Okay.
They take so I haven't been able to enjoy my home
condo. I'm sorry.
In March.
Where you lay your head? Do they take you to and from where you lay your head?
99% of the time.
This was a year ago.
Mr. Wade,
can you believe that?
Wherever you laid your head.
That has never in the history of ever happened. Ever. Okay.
Your security team has never taken him
from my house. That's a lie.
That's another. If they've ever taken him anywhere.
And I'm telling you that that's never happened.
So your security team has never taken
my
Mr. Wade
security
anywhere.
team has never taken Mr. Wade from any place where I have lived and brought him here. Never. Not once. Not ever.
And that's the information
they the two of you together.
What's this interaction? What's the money?
We've left this building and gone to lunch, but I go to lunch so rarely that is a very rare occasion. I am sure, and let me be clear, it wouldn't just be Mr. Wade. So I'm sure my security team has taken me to lunch. Probably been a time I've left here 7 o'clock, gone to get something to eat. And I don't even know that they would have taken him or if he would have driven himself, but they've taken me to do that. But we're talking very few, very far in between. Most days I don't even eat lunch. And when I do, it's because my assistant has heated up some bag, something, and I eat through meetings and eat in my office. It's not a practice of mine to go to lunch.
During the time period that you were dating, would your security team ever take you two together anywhere?
No.
Never.
If there was a lunch that occurred that I just described, if there was a meal that occurred that I just described, anything outside of that, and it needs to be very clear. Not often. Once, twice. Because I want to be over-inclusive.
Oh, yeah.
I'm saying once or twice. I'm not certain that it happened, but I'd rather be over-inclusive with you.
Mm-hmm. Here
So
comes our
your
moment.
office objected to us getting Delta records for flights that you may have taken with Mr. Wade.
And, no, look. I object to you getting records. You've been intrusive into people's personal lives. You're confused. You think I'm on trial. These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial.
So my question was, do you have any problem?
I object to getting any personal records of mine.
We're not dealing with privilege through a witness.
And I'm not, no, I'm not dealing with privilege. What we had offered to put them in camera for the court to review, and I just want to know if she has any
That's
problem.
not something you deal with a witness.
Okay, you have to file as part of your job something called an income and financial disclosure report, correct?
That's correct.
And you filed your first one, so you filed 2 to date, is that right?
Is it 2 or 3? I probably would have filed 21, 22, and maybe I haven't filed 23 yet, because isn't it due like June of the next year?
April, I believe. So you filed, let's see, you filed your first one, it looks like April 15th, 2022, and your second one, April 17th, 2023. Does that sound familiar?
That I don't remember the dates, but you're an officer of the court. I'm gonna hope you're telling the truth now.
Oh boy!
All right.
Okay. And anyhow, Fani Willis has lost at every single step in every single court. And Ashley Willis is, as we have labeled her, Fani Willis's worst nightmare. But
and one thing the court pointed out was, the argument by Fani Willis was that, hey, it's moot now because that board that was investigating has now disbanded and it's a new term. Right. The court said that would be absurd to think that you can just wait it out, wait till the board ends their term, and then decide that's the reason you haven't complied with the subpoena.
Right. We're not buying that.
No, we're going to talk to Ashley in the next few days, next week, hopefully, and get her take on this. But she ain't backing down, and Fani's getting, just pushed into a corner more tightly. She's going to have to cough it up.
Yeah, and neither are the courts. Remember, there's you have Ashley Merchant suits, but then you also have what is Judicial Watch. Don't they have
right? Tom. I was going to say Tom. Yeah.
Michael's on first name basis. That's all.
Yeah, that's right.
Yeah. So yeah, we'll talk more about that next week. But we did want to let you know because that was just hot off the presses. And tomorrow night we'll be talking more about Reed, and we'll also be talking about another dislikable. Well, not about Reed, but a real dislikable.
We didn't get into this because we didn't have time. But the Adelson testimony, Dawn Adelson trying to get bond and get out of jail prior to her trial. This is the trial we almost went down to in Tallahassee, and then they canceled at the last minute because of the conflict of interest with the attorneys. Right? Is that right?
Right.
So that's I just want to get into that testimony because it's really kind of
I'm sorry.
Domino.
I'm sorry. Your wife was a Domino. Domino wasn't going with Lisa. Domino was coming in just like two people barking at me. We're dog friendly, by the way. Our show is dog friendly. In case you haven't noticed, right?
So I just thought it was amusing because she's whining about she has narrow ear canals and gets a lot of wax in them, so she can't hear, and it's inconvenient and annoying. And she was assaulted, and her arm got hurt, and she cut her arm. And you know what's also annoying and really kind of messes up your day? Being shot in the head point blank by somebody outside your car when you're in your own garage on your cell phone. That can ruin your day. So
also that she's gained weight because she's put on like 30% over her weight because her diet is one of carbohydrates and not of protein.
Yeah, it's a sad story, but I think it's worth pursuing just because we know that trial's coming, and she's a character. So we'll get into that tomorrow, unless something crazy happens.
Right.
And probably we'll have a Reed decision too.
Well, right? I assume we're going to have a Reed decision. So what time we think of tomorrow night? 5 o'clock or 6 o'clock? 5 or 6?
6-ish, I guess. I don't know unless you have dinner. You got dinner plans. You want to get out
I don't seem to have a life.
Are you still married?
I don't know. My husband's in Rochester testifying for the Lewin in Rochester. So
5 or 6. We'll figure that out.
Whatever it is,
5 or 6. 5 or 6. Anyhow, all right. So we'll see you then. In the meantime, I'm Michael Bryant. Try to do the right thing.
And I'm Linda Kenny Bodden. And together we are Justice Served TV. And we ask you to hit that like button, subscribe, hit the notify button, and also share the podcast or the streaming channel, as we like to call ourselves. And we will see you tomorrow night.